My name is Stephanie Brown and I'm a solicitor at Lynch Family Lawyers. The COVID-19 pandemic has caused great change and very quickly in our world, and this is included in the family law space. At the moment, the courts are prioritising urgent parenting matters, and their preference is for hearings to be run by telephone where that is possible. This is an ever-changing system, and the court are releasing constant updates in relation to their hearing processes. It's also an important time to consider any parenting orders that may be in place, as the COVID-19 outbreak isn't dealt with in those orders, and it may require parties considering new arrangements for care of children, particularly in circumstances where schools or activities may be closed or cancelled. It's important to consider changeover locations and other options around parenting arrangements. It might also be a time to consider alternate caregivers for children if grandparents have previously taken up that role. Grandparents are in the high risk category for COVID-19, and you may need to consider other arrangements for children in those circumstances. In the event you are changing parenting arrangements, it's important that communication with the other parent is clear and in writing where possible. If you are looking at more long-term changes to parenting arrangements, you may need to consider obtaining legal advice prior to making any of those changes permanent. In relation to domestic violence orders, these will of course continue to operate, and you may need to consider what will happen if family law exemptions under those orders aren't able to apply, for example, if changeovers generally occur at school. Again, a breach of a domestic violence order is a very serious matter, and therefore it may be important to seek legal advice and to open up communications with the other parent if that's necessary.